Australia is a proud representative of our human rights. However, each year Australia has been criticised by the Human Rights Watch report for our undeniable issues with Indigenous rights, including their overrepresentation in our prisons and legal system. Good morning, Minister for Indigenous Affairs. I am grateful for the pleasure to bring forth this issue into the spotlight, and with faith come to a resolution to cease its ever-growing occurrence. When Australia was classified as terra nullius by Captain James Cook in 1770, Indigenous Australians would lose the right to their land and be forced to abide by British law. Conditions would worsen for the Indigenous when the government would force children out of their families and communities under the Aboriginal Ordinance 1911 Act, and place them into government or church-run institutions and white families. It would last up to 1969 when federal powers repealed all legislation stopping governments from removing children from their families. It would not be until 193 years after terra nullius when the first attempt to assert land rights was established through the Yalaka Bark Petitions in 1963. Trying to prevent mining corporations on Arnhem Land, the Yalaka people were denied these rights from the government under terra nullius. Influenced by the US civil rights movement, the Freedom Ride, led by Charlie Perkins in 1965, contained a bus full of university students who travelled through regional New South Wales towns protesting segregation. It is said to have escalated the awareness of the campaign leading up to the 1967 referendum. Beginning in 1982, Eddie Mabo and 4 other Torres Strait Islanders took Queensland to court seeking a declaration of native title over Murray Island. It would not be until 10 years later that it was recognisable that Mabo held native title, even though he passed away before a decision was announced. Using the Mabo v Queensland 1992 case, the Whig people were able to use precedent in claiming native title over the land that had been leased by the state government. It was decided in 1996 that they narrowly won their case over native title over Cape York. Kevin Rudd, on behalf of the Australian government, will present his famous sorry speech, a report apologising to the Indigenous Australians stating, "The time has now come for the nation to turn a new page in Australia's history, by righting the wrongs of the past and so moving forward with confidence to the future." Even in 2019, Indigenous society is still disadvantaged. In particular, our legal system has an overrepresentation of this minority group. This simply means that the total number of Indigenous prisoners is disproportionate to our total population. Our Aboriginal population makes up approximately 3% of Australia's numbers, yet they cover 53% of our prison and juvenile rates. Currently, the federal or state parliaments have not introduced any laws regarding resolving Indigenous imprisonment rates. However, a Royal Commission into Aboriginal Deaths in Custodies was established from 1987 to 1991. It made numerous discoveries and also listed 330 recommendations, which only a few were ever implemented. Since the Royal Commission, Indigenous Australians are 10 times more likely to be in prison, with the percentage of Aboriginal deaths in custody rising 150%. This has been discovered as a consequence of ongoing and systematic disconnection from their customary law, traditional culture and land. The United Nations General Assembly introduced the ICCPR in 1966. Its signatories committed to respect the civil and political rights of individuals. However, Australia would disobey international law, failing its civilians. In 1975, the federal government introduced the Racial Discrimination Act after finding a strong link between racist conduct and public and racially motivated violence. It was designed to remove the ability of Australians to discriminate against each other, with the consequence of a costly sentence. Section 18C has made it unlawful for someone to offend, insult or humiliate a person based on the colour of their skin or cultural background. A distinguishing case in the process of sentencing Aboriginals under Australian law was R. v. Fernando 1992, which was a decision handed down in the New South Wales Court of Criminal Appeal. 8 propositions were effectively represented to create a relationship between Aboriginality and the sentencing process. These included the removal of racial prejudice, the inclusion of Indigenous heritage, and external factors impacting on the crime. Created in the same year, the Penalties and Sentencing Act 1992 was designed to set a guide in the sentencing process, combining numerous factors including age, background, and capacity. This would provide a fair outcome of each conviction, however has failed in our modern society. 27 years later, in 2016, the University of Technology uncovered racial prejudice in the judicial system, in particular magistrates in rural communities. An outcome of this is shown when a child was placed in juvenile detention after stealing bottles of soda water, contributing to the population of more than half the juvenile prison rates.